ready?
No.
Your Honor, Mr. Blackwell is on his way down.
Yeah, I think we did say 8:45 at one point earlier this week, but last night I thought I did say 8:30. So, but I understand. Grab you at the moment you come in the door.
No, I think I'm ready to proceed.
All right.
Judge Cahill.
All right.
It would be useful for me, Your Honor. Obviously, we agree with the ruling Your Honor made on this a few days ago.
Right.
And Your Honor has had a chance to give it some further thought. And it would be helpful for me as a starting point to have the benefit of Your Honor's thinking now.
Where am I at? Is it, in other words, where am I at?
Yes, that's
Yeah,
right, Your Honor.
I think that's appropriate. When we left this issue last time, I had said it would appear to me that the expert testimony of Dr. Vinson would be admissible on the fairly narrow issues of Mr. Floyd's emotional response on May 25th were consistent with the claustrophobic reaction, anxiety, or panic attack. Subsequent to that, when we were talking about the May 6th separate issue, May 6, 2019 issue, and part of the defense offer of proof was they wanted to show that this was a common scheme or plan, and that, or modus operandi, that Mr. Floyd's emotional state and statements were very similar, if not identical. And I had ruled earlier, and I stand by that ruling, that Mr. Floyd's emotional state on May 6, 2019, and the statements he made really aren't relevant because his intent is not an issue here. And whether his statements and emotional response was feigned or if it was genuine doesn't really matter, because the question is, what behavior did the police have to deal with, whether it was genuine or not? And I told the defense that's irrelevant, which made me realize isn't the same thing true on the May 25th date. And so it seems that Dr. Vinson's testimony is the same testimony that I precluded the defense from offering regarding May 6th. In fact, that was the original ruling on the the reverse Spiegel the defense offered on the May 6th incident until this new evidence came forward. It is not the court's intent to reverse that part of the May 6th ruling, that emotions, his response, his statements, whether he was crying or not, are not really relevant, because his intent, his emotional state, and whether he was feigning or had a genuine response are not relevant. So that gets us back to May 25th. How does it become relevant? Because the defendant's intent is clearly an issue, but not Mr. Floyd. So that's kind of where I'm at.
All right. Your Honor, the interpretations over George Floyd's behaviors are, in fact, what's relevant with respect to May 25th. As Your Honor has heard from the defense, practically every time they describe the incident of what happened on that date, they talk about George Floyd's behaviors and interpreting it, resisting arrest, fabricating difficulty breathing, that it's somehow either fabricated or reflective of a cardiopulmonary condition or drug addiction.
I don't want to interrupt you, but I have no problem with the behaviors. For example, they are saying resisting arrest. I think it's, when you watch the video, that behavior is clear. It's, what's going through his mind, that's a concern. So I guess let's talk about that.
Yes, Your Honor. The behaviors don't speak for themselves necessarily. We can see them. It's how they get characterized by the defense that we are rebutting. That if we look at the videotape, for example, and we could see, for example, they're telling George Floyd to get in the squad car, 320, and they find that he's not compliant. Does the non-compliance mean that he's resisting arrest? Or does it mean that he's not capable of getting in the squad car because he's suffering from the effects of anxiety or panic. And the way that this issue comes up in terms of his behaviors is the defense has been free to characterize George Floyd's behaviors in any way they choose. Typically in a light that's not very flattering to him, that is obviously pro-defense, as you might expect. But it's a free kick at the goal if we're not allowed to offer alternative explanations for the same behavior. That wouldn't be a diagnosis of George Floyd. It would be more the general testimony from Dr. Vinson that a person who has encountered a traumatic event, as George Floyd had, just any general human, would be expected to have a reaction that would manifest anxiety, etc. And here's what this looks like in terms of behaviors. Frozen by fear and panic. Shortness of breath, difficulty breathing. It's not a heart problem, it's a panic problem. And so Dr. Vinson's test.
Do you have a doctor who's going to say that?
Dr. Vinson will be the doctor. She's an MD, triple board certified, Your Honor, in forensic psychiatry, adult and adolescent medicine, and again, forensic psychiatry. So she would be the expert who would be qualified to talk about the way that a human being would respond to a traumatic event. As Your Honor knows, George Floyd had only recently had a gun put in his face, and the risk of having, frankly, his head blown off over the investigation of a fake $20 bill by the police. That is a situation that would cause trauma to any human being. And so how he responds to that, the feeling that he was going to die if he were put into the squad car, which he said repeatedly, how would a general human being respond to that from an anxiety point of view? How does that manifest in terms of behaviors and conduct? Is that an alternate explanation to the narrative put forth by the defense that it can only mean resisting arrest, it can only mean drug intoxication, it can only mean fabrication? It's an alternate explanation. And if this type of testimony is completely irrelevant, then it would have to be irrelevant to both sides. And meaning if we're not able to offer an alternate explanation, then the defense shouldn't be allowed to stand up to say that George Floyd was resisting arrest, which is an interpretation, to stand up and say he's fabricating any of this, which is an interpretation of his behavior, to suggest that it was drug-induced or related, which is an interpretation of his behavior. So either both sides can put forth their explanations for the behavior, some of which is psychologically conditionally based. Either both sides can or neither side can. And I'm certain that that is what the defense intends to do, is what Your Honor has already heard repeatedly in this trial. So that's the first reason it's relevant, Your Honor. But a second reason is that it goes to the issue of medical causation. Is it true or not true that when Mr. Floyd is saying that he has a shortness of breath when they're trying to force him into the squad car, is that reflective of a heart problem, a lung problem, or does it relate to issues of panic or anxiety?
Well, let me stop you there. I read the report of Dr. Vinson, and she's an MD but not a pathologist.
Right,
Is she going to say to a reasonable degree of medical certainty that the shortness of breath was due to a panic attack and not to a heart condition?
No, Your Honor. And as Your Honor recalls in our discussion of the case of State versus McClendon that deals with the introduction of evidence on psychological condition evidence, the dividing line that gets drawn is that such an expert, and Dr. Vinson is a forensic psychiatrist, so she
Yes.
deals with the interface, again, of science and medicine, but in the realm of psychiatry. The dividing line that is drawn is that the expert can provide general testimony as how a general human being would respond to a traumatic event, the type of event that you would expect a human to have a reaction to. You would expect this panoply of reactions. She can describe what they are. She can't then take the next step to build the bridge to diagnose Mr. Floyd. So simply giving that to the jury as an alternate explanation, sort of medically, if the defense has jumped to the conclusion that we're looking at the same facts and the same evidence, and they jump to the conclusion that it's indicative of a heart problem, then she's at least should be allowed to offer to the jury that an explanation that should be on the list for any type of a differential diagnosis is that this may be reflective of simply anxiety or panic, because that's what happens in humans who suffer traumatic events this way. And that is in the wheelhouse of a forensic psychiatrist, to give that kind of testimony, which it would be the behavioral manifestations of what might be psychological conditions in response to a traumatic event. And that would be her wheelhouse. But Judge Cahill, I think this is relevant in one other area too, and this goes to the issue of the objective reasonableness of Mr. Chauvin's conduct. And the assessment, again, of those behaviors matters even for objective reasonableness. I would refer the court to the Minneapolis Police Department use of force policy on de-escalation, from which I am reading: when safe and feasible, officers shall consider whether a subject's lack of compliance is a deliberate attempt to resist or an inability to comply based on factors including, but not limited to, on the list, behavioral crisis. Behavioral crisis. So we ought not be precluded from introducing generic evidence relating to those psychological conditions that would reflect a behavioral crisis, that is, circumstances that Mr. Chauvin should have considered, for the jury to consider whether those existed in the totality of circumstances that Mr. Chauvin would have experienced. And the fundamental question is, would a reasonable officer not have recognized a behavioral crisis and not employed the force that Mr. Chauvin did, is the question. And to the extent those behavioral crisis issues are at issue in the case, then having an expert who can explain medically what they are is helpful to the jury, just to understand. In the same way that the police are trained on the risk or hazards of putting people in a dangerous, deadly prone position, having an expert to explain how that manifests or affects humans is helpful to the jury.
Well, if you put that in issue, I've already signaled that I'm considering allowing the May 6th, 2019 case limited, for example, to the officer's approach of the car, Mr. Floyd eating drugs, and then subsequent to that being examined by a paramedic and his the indication that Mr. Floyd was in a hypertensive emergency with a systolic blood pressure over 200. If I grant your motion and allow Dr. Vinson to testify as to, claustrophobia, anxiety, panic attacks have these results or manifestations, and that they include shortness of breath, essentially giving the state reason to argue that the jury should infer that it was a genuine anxiety response, not active resisting. Don't I also have to then allow the defense to talk about the May 6th, the similar thing, not just the contact, eating the drugs, and then fast forward to the paramedics' treatment, but actually allow everything they want, which is what he was saying, how he was emotional? Don't you think that if I give that to you, I have to also allow the defense to do that?
You ought to know, I think that's in a way, it's a false comparison. That in both instances, it's the defense that's the proponent. It's the defense that is attempting to pursue the May 2019 incident, and it's the defense that's characterizing Mr. Floyd's behaviors in ways that we think are imbalanced and unfair. So with respect to the May 25th incident.
Well, let me stop you there. But if you put in this evidence, they are entitled to contest it and rebut it.
No, it's us who's rebutting the defense assertion. If the defense does not assert that Mr. Floyd was resisting arrest, interpreting his conduct, if the defense doesn't assert that Mr. Floyd was faking claustrophobia, the defense interpretation, if they don't make those assertions, then we're not rebutting it with Dr. Vinson.
Well, let's be clear. Are we talking about evidence? I'm not going to allow them to present evidence that he's faking, somebody's opinion, oh, he's faking. Just like the state is saying, it's genuine. It's more a matter of argument. In closing argument, either counsel can say, look at this. This is clearly somebody who's resisting arrest and is faking his response. Where the state would say, how can you say that's faking? He's clearly short of breath and he's panicking. That's usually a matter of argument, not evidence.
Well, if we want to make the argument, though, Your Honor, that what the jury is seeing is reflective of panic or anxiety, it certainly would have been helpful to the jury for them to have heard someone testify as to how these various conditions are reflective of anxiety or panic, such that they have a foundation from the evidence and not just from lawyer argument. And I'm certain that Mr. Nelson is going to make these kind of arguments about Mr. Floyd. Your Honor has heard it repeatedly already, the reference to resisting arrest, evidence of everything being related to drug use, that the defense is doing a full-on trial of George Floyd, who's not on trial, but that is what they're doing. And well, that's our point of view, Your Honor. And so if the court were to rule that the defense, that neither side is allowed to characterize Mr. Floyd's behaviors, that we don't get to bring in a Dr. Vinson to say that the behaviors are reflective of anxiety or panic attack. On the other hand, the prosecution doesn't get to accuse him of resisting arrest.
Well, here's the other part. It's not mutually exclusive that someone is in a mental health crisis and is also resisting arrest. Would you agree with that?
Well, Your Honor, not without the use of expert testimony in that regard, because...
Oh, let's go into a more hypothetical. Someone is having a mental health crisis. They are removed from this case completely, and they start to thrash about and refuse to get handcuffed. An intentional act, refusing to be handcuffed, refusing to whatever, it may be due. Their behavior may have been induced by a mental health crisis, but it's still resisting arrest. Wouldn't you agree with that?
Well, I would agree that it's non-compliant, and the difference we're having, Your Honor, is definitional. When I conceive of resisting arrest, it suggests that there is an intention, that the person is able to form an intention and is in fact acting on the intention to resist arrest, as opposed to simply non-compliant. The police policies and procedures speak in terms of non-compliant behavior, and that then the police have to make an assessment as to whether the non-compliance is resisting arrest as opposed to an inability to comply.
Because of the policy?
By the policy and the training.
Okay.
And so there's a difference. But to Your Honor's initial question, essentially, is it not fair to allow in the May 2019, if we're allowed to have Dr. Vinson then put in testimony about George Floyd's behaviors? Our testimony with respect to Dr. Vinson in that regard is rebuttal testimony in nature. It is rebutting the assertion from the defendants that George Floyd's behavior can only mean one thing, and it's the things that the defense has asserted. We think that's an unfair conclusion, and the jury is entitled to have the alternative explanation for it, because the defense has made that assertion, an unfair assertion that's jumped to a conclusion. And but for the defense doing that, we wouldn't have a need to inform the jury of an alternate explanation or to illuminate as to how the defense has jumped to a conclusion in making that assertion about George Floyd's behavior.
Well, here's where you're talking about rebutting the defense. When we're talking about your case in chief, how can you rebut something? I don't care if they said it in motion hearings. The jury doesn't know any of this. It's about what the evidence is, and you can't rebut prospective evidence. And it seems to me that it's either both come in or neither come in.
Well, if Your Honor, in the line of cases that deal with the admission of psychological condition evidence, the right of the prosecution or party to introduce that evidence can be itself triggered by statements made even in the opening statement, such that the prosecutor doesn't have to wait if it's already been put into the case in an opening statement. It's in the nature of rebuttal testimony, but it doesn't have to wait to a rebutting if it's already been put into the case and the jury's already heard it. And so if they hear, for example, Mr. Nelson stand up and say, here you can see George Floyd is resisting arrest in his opening statement. And so he's gone and made that assertion. When we're putting our case in chief, we can say you heard them say this. That is jumping to a conclusion. There is an alternative explanation for that. that relates to how one behaves when they have a panic or an anxiety attack from a traumatic event such as George Floyd encountered. Not diagnosing George Floyd, any human being who went through such a traumatic event.
All right. All right, Mr. Nelson.
Thank you, Your Honor. Your Honor, I think the court hits the nail kind of square on the head. I mean, this is a criminal trial, right? Parties are permitted to introduce evidence, draw in closing arguments, that's my job as a lawyer, is to draw inferences from that evidence. What do witnesses say? What's happening in videos? All of this. This is the very nature. And both sides are allowed to introduce information that rebuts that. I think the court is 100% correct. They either both come in or neither come in the context of the emotional state of Mr. Floyd, right? If the defense takes the perspective that what Mr. Floyd is doing, and I'm just going to ask if we can silence computers because it's really distracting. Someone's computer keeps dinging.
Please, everyone. Thank you.
In the context of the evidence of this case, right? The jury will see videotape, they'll see body camera footage, they're going to hear from witnesses who describe what they see and observe and hear and things of that nature. This is the entire nature of the adversarial system. Here's the evidence. This is how the state interprets the evidence. This is how the defense interprets the evidence. Jury, you decide which interpretation is correct. But what's good for the goose is good for the gander, right? If the state is going to say, if I'm making the inference that Mr. Floyd was resisting arrest in the course, or he was exaggerating his condition, or he was actually experiencing a medical condition that went unrecognized by police officers, the state can theoretically bring in evidence to say here's an alternative explanation for that. Again, I think it's limited in this particular context, but that then opens the door. That's the precise issue, is it opens the door to say, he's saying he's claustrophobic here, but in a prior incident that's remarkably similar, that's not an issue. He gets right into the squad car, right? So it rebuts that assumption. That's the nature of the adversarial system, and I think the court understands that. We've tried lots of cases. The court has tried, a large number of cases, and understands the inferences that can be drawn from evidence. But what's good for the goose is good for the gander, and it opens the door.
All right. I'm going to take this under advisement until tomorrow. It'll be part of the rulings on the continuance, change of venue, the May 6th, 2019 other evidence that I've already outlined, and then Dr. Vinson, and we'll go from there. So we'll do these rulings tomorrow morning. So, all right, I think, where are we on jurors?
You're ready.
All right. Let's just take a quick 10-minute stretch break.